this idea of judicial services career or continuous legal education program, or the basic legal education program for new entrants to the law field, is the idea of Jayant Jaibhave sir, who is mentor for all of us. And Jaibhave sir is practicing since last more than 40 years at Nashik District Court. Sir has written number of books on CPC, evidence in civil trials, etc. Sir has delivered various lectures and guided number of advocates for judicial examinations and other purposes. I request sir to start with his lecture speech on CPC. Thank you so much.
Thank you very much. The pioneer supporter of this activity, my friend Advocate Ganesh Pawar, the another coordinator and great supporter of the activity, Sujata Madam, all other coordinators present, Dr. Rajendra Anbule, who has taken the responsibility for carrying this entire activity for the training of the young advocates who are appearing for the JMFC exam. And also my young friends, participants who are aspirants to join the judiciary, and therefore they have appeared to this exam. They have completed the prelim and now they are having the mains exam on this 29 September. So friends, first of all, my best wishes. We want a lot of judges in the judiciary, and the young advocates who will be succeeded in this exam will be taking a great responsibility of doing a justice in a country. And therefore, I express my, first of all, the best wishes to them in this program of judicial service as career. Today, the topic which is given to me is on the repeated topics of the Civil Procedure Code, which appears in this examination. This being a vast subject, definitely all the topics cannot be touched in this short time, but I have verified the coordinators and particularly Dr. Rajendra Anbule and Ganesh Pawar was kind enough to send me the set of question papers by making a distribution of the questions on civil procedure of last 10 years. And after perusing these all question papers, the repeated topics which are coming in this examination, I have selected some of the topics out of that. So in spite of talking in general on the subject, I will concentrate because the purpose of the program is to give some inputs in the best possible manner to the candidates who are appearing for the exams. So that topics I will deal with. I had a important 8-9 topics which I have taken from these question papers. So I will one by one come to that topic. Before coming to that topic, I will just, as a introduction of the subject, I will put my own bird eye view on the Civil Procedure Code. And after practicing on the civil side for last 37 years, my own experience, my personal experience as an advocate is that we are not able to explore the entire provisions of the CVC, even to the extent of 20-30% perfectly. We do a general advocacy. We don't see the sequence of the code. And if that sequence of the code is seen, you can understand that it's a logical sequence based on the natural principle of justice, a very simple logical sequence. And on that, a particular code has been drafted, which includes a first part is of a sections. Then second part is of an order. The third part is of an appendix attached to the code. That is also important because it's a part of the code. Appendix, particularly A, which is a pleading, a model pleading given in a civil procedure code for drafting the suits. So one has to see that minimum that pleadings are appearing in a plaint or written statement. So there are three parts. A, section 1 to 158. B, orders, order 1 to order 51, and the rules thereunder. C, the appendix, which is attached to the code, where the pleadings and the other aspects are also given. That is also the part of the code. This includes A plus B plus C, the civil procedure code. So one has to properly study the index, the initial index of the code, and keep your mind ready to travel on this track of conducting civil trial by using the civil procedure code. This makes very easy to go ahead with the civil trial and the use and for using appropriate provision at appropriate stages, because it is divided into the different stages. At this stage, pleading; at this stage, summons; at this stage, the filing of the document; at this stage, the framing of the charge; at this stage, the evidence; at this stage, the judgment; at this stage, the decree; then the execution, the appeal, the revision, etc. These particular stages of the civil litigation, accordingly, the draft of the code is prepared, and we have to understood this logical sequence which is there in the code. So for that purpose, the first and a very simple way of making a study of the civil procedure code is to understand the index, initial index of the topics, the sections, the parts of the sections, how they are divided into different parts, why that parts are made. If it is for the section 9, section 9 to section suppose 34 is there, it is a suits in general provisions. If it is execution, you should understand which section is there for the execution. Then that particular section is to be correlated with orders. So sections and orders are to be connected by the lawyer when he does a practice. So that makes a sense, proper sense of making an application, because sections are also there, orders are also there. Order is nothing but the rules. In a statute, any statute, rule making power is there, but rules are independently framed. You take any other act. You take the Maharashtra Land Revenue Code. You take the Maharashtra Regional Town Planning Act. Any other act. The act does not contain the rules. The act is of sections. There is one rule making power, and by use of that rule making power, an independent document of rules is prepared. This is not a case of CPC. CPC has included the rules. Section is there, appendix is there, everything is collected and put for your use for conducting a civil trial. And therefore, it is a code. The simple meaning of the code is a collection of all these things. And therefore, a logical sequence, the way this procedure is given in your hand, must be understood. For that, 1, 2, 3, 4 times, if you see how it is subdivided, you get an understanding that yes, there is one logical sequence. A short time, and therefore I'm not taking your much time on that particular aspect. So this together forms a code. Also, in addition to this, there are various high court amendments. We are in a state of Maharashtra, so under section 121 to 135 of the Civil Procedure Code, there is a power given to the High Court, concerned High Court of every state to make their own rules for the purpose of further carrying the procedure of civil trial or civil litigation. Accordingly, many high courts have drafted their own rules. They have carried out certain amendments, mainly in the orders, because orders are the rules. Section is a substantial law. Even in a section, the state amendments can be done, but that will have to be done by the legislation because it's an enactment. High Court can't do an enactment, but High Court can frame the rules for the procedure. That power is there, and that by using that power from section 121 onwards, High Court has framed certain their own procedure applicable to that particular High Court, jurisdiction of the High Court. If it is Bombay, then it is for Bombay, Goa, and all that other places where the jurisdiction is there. For them, this is the High Court amendments. We call them as a Bombay High Court amendments. It's a fourth aspect. As we say, initially it is sections and orders and appendix. Attached to that, there is a fourth segment of the code. These are the Bombay High Court amendments to the code. They are very important, friends. I have seen in many of the seminars and lectures, particularly in a continuous legal education programs, where the interactions are there. And if 100 students are there, hardly one or two knows that there are such High Court amendments to the code of CPC. And that particular amendments are to the point. They are practical one. They are to be understood and used for the purpose of proper application. Should be properly purchased. Even a bare act you are purchasing, I always recommend that try to find out the bare act published by the government printing press. I again repeat, and I will still repeat, it's the easiest way of understanding an enactment like CPC or CRPC or Evidence Act. It is perfectly drafted. You have in a side margin the notings, a particular way of drafting rather than using the commercial bare acts. Try to find out that government printed bare act, at least of the CPC, Evidence Act, and CRPC. I will say that for all acts should be tried to be. I know that's easy, it's available everywhere, but if you try it, you can get it. Particularly CPC, I always recommend that you should use that particular book. It is easy. There is no commentaries. It is not burdened with the case law, and therefore a big concept of the procedure that makes you aware that you have to travel in this particular way. You have to see the basic provision. And friends, therefore, a lawyer practicing on civil side should always understand any application made for any civil or criminal litigation is to be done under some provision of CPC or so is to ascertain the procedure under which you are making that application. Any difficulty, Ganesh, in a voice? Some of the messages are coming. Hello? Hello? Hello?
Sir, I think network problem is there because of which voice is breaking.
Okay. But today the entire network is failed. So whatever best possible way, or if I think it is recorded also, no?
But sir, in recording also, if your voice or your network is poor, then recording will also be poor.
So shall I record on my own this mobile? Because today the problem is there. Even I was not getting even one or any call today because it is something problem is there. But anyway, they have to continue, friends. No, I hope that we will.
Yes, sir. Yes, sir.
No?
Let's
I will
continue.
be
Yes.
slow in a speed. Therefore, no, I will be quite slightly slow in a speed. I will try to deliver in a slow speed so that
Yes.
as far as possible there should not be any interruption. Okay. If you are not getting friends voice, just put the message. Huh? So
Yes,
we
sir.
will find out some solution.
Yes.
But as far as this concerns is there, this the network issues is there. Okay. So we can't do. We are totally dependent on the now network, and therefore we are not far for virtual hearings also. So ultimately we have to rely on the physical hearings more. Ganesh, you are getting no my voice? Ganesh?
Yes, sir. Yes, sir. Yes, sir.
I'll continue then. Okay.
Yes. Yes.
Yes. So I was on this point that every application is to be made under some provision. And that should be understood. Even an adjournment application is to be made. It is to be made under the order 18, rule 17, or any available other rules. Most of the times we only know one section, 151. It is like a joker in the cat. And that anytime we text that joker and try to solve our problem, they decide 151 खाली आहे ना तरतूद. But it is not the case. There is every provision for every particular act, and that exactly appropriate provisions are to be find out by the really practicing advocates also. And when you are going to be a judge, friends, now 4 parts I have told you. You try to compare this, how sections are connected with orders, how sections and orders are connected with the High Court amendments, and the most important document which will be in your hand when you will become a judges, and you must read that. That is a civil manual. These 3 things, sections, orders, High Court amendments, are ultimately explained in detail. In elaborately, they are explained in civil manual. Civil manual. I don't know. I will just call upon my young friends to put their message, whether they know civil manual, whether they have read the civil manual, and if not, I will say that kindly purchase the civil manual of Gupte, which is for Bombay High Court, and this civil manual will solve many doubts in your mind on a particular topics. And you can take any topic. You will get a detailed procedure. If you want to talk about the commissioner provision under order 26 is there. The commissioner provision under section 75, 74, whatever may be there, it is there. But a elaborate procedure of the appointment of the commissioner, how notices are to be issued, the way of making a service, these are all available in a civil manual. So you can have an elaborate procedure explained on every point on a civil manual. So this is the way of dealing with the CPC. You should understood this connections intersect, and therefore, for an initial introduction, I have taken you this time. So let us now go to the topics. Whatever best possible, we can deal with for execution purpose in decree. So decree is a formal expression of adjudication done in the court. A and B are fighting, and because of the fight of A and B, adjudication is done. Adjudication is done after the framing of the issues, after evidence. It may be oral, it may be documentary. Honorable court has given a finding on each issues, which are framed by the court on the basis of the pleadings of the parties. This adjudication, this is a process of adjudication, pleading, issues, evidence, oral or documentary. Out of this adjudication process, judgment is delivered by the court. Judgment is delivered by giving a reasoning on each and every issues framed on the court, by the court. Judgment is with reasons, having the ultimate operative order, and decree is a formal expression of the result which has been declared by the court in that judgment. So therefore, a simple definition, if you see of the word decree given in section 2, subclause 2, 2A of 2.2 of the Civil Procedure Code, the decree is defined. In section 2A, the judgment is defined. In section 2.2, decree is defined. It's a formal expression of the adjudication, first part. Secondly, in these formal expressions, as far as possible, court has declared the rights of the parties who are party to the litigation. And court has also dealt with all the controversies which are there in the suits. That controversial points and decision thereof is also reflected in a decree. So this can be a preliminary decree also, and this can be a final decree also. So when you are writing a question and answer on a point of a decree, it is important, friend, that you should understand what is the difference between the judgment and a decree. Of course, the lawyer knows that. He has studied in the law, court of law, that what is a judgment and what is a decree. Then why it was necessary to have these two documents independently, judgment and decree. Judgment, how it is to be done, is dealt by some of the provisions. It includes section 33 of the Civil Procedure Code. It includes order 20 Rule 1 to 20, and also it includes into Civil Manual para number 267 to 288. Those who are having a civil manual, I'll request them that go to that civil manual, go to that order rule 1 to 20, and then see what is the when then you can, just by reading the provisions, rather than reading any big judgment on that particular aspect or reading some big commentary, simply you can understand that what is judgment and what is decree. So if a question comes that define decree or judgment, and write your comparative note on a difference between judgment and a decree, because that is the main aspect of the judge. He should know. And I hope that these are the questions repeated in your exams. Explain decree, what is preliminary decree, what is final decree, what is ex-parte decree, what is judgment, what are the difference between the judgment and a decree. These are all the questions which are repeatedly coming in exams. So to cover up all these questions without taking a single questions, one should understand that judgment and decree are two different things. Judgment is to be dealt with in accordance to these all provisions, and in there certain principles are you can go to order 20, you can go to the section 33. You will find out for a judgment, the first and most important principle is that the judgment must be given on judgment and decree, both these things. This can be delivered only when the court has the jurisdiction. Then judgment is to be declared after completing the hearing, and it is to be dictated or declared in an open court. It is not something a confidential thing. This is equally related to the basic principle of the justice, that justice is not to be done, it must be seen to be done. You must have heard all these things, that justice is not to be done, seen to be done. Means what? Means the judgment and the hearing of the court is an open thing. Any person can go and sit and hear the hearing. He can be an audience. We only see in these movies, but in a practically course, they were so small premises. And nowadays, after COVID, practically everybody is in a camera. In fact, the concept is exactly opposite. The court is open court unless specifically directed by the court that it is to be, the matter is to be conducted in camera. It is open court. So justice is to be done. It should be seen to be done. And therefore judgment, as per order 20 rules, the judgment must be delivered in an open court. There are certain limitations. Judgment is to be given within 30 days from the hearing is completed. There must be a finding on all issues given. The judgment, which is written by one judge, but it is not pronounced by that judge. If it's his another successor comes there, he can declare that judgment. Of course, it's his own decision whether he should continue with that judgment or whether he can go for a final again arguments. It's not necessary. It's not a de novo trial as it is in a criminal, that evidence is to be recorded again. But he can again ask for the arguments, and then he can give a judgment on the given evidence. But Order 20, Rule 7 gives a power that he can also pronounce that judgment which is written by his pre-successor. So that provision is there. It must be signed by the judge. It should be signed by the judge. And if the advocate is not there, it is a duty of the court, that is a judge, to inform the parties that after the judgment, there is a provision of an appeal and you can go for that appeal. In fact, now the procedure is that the appeal is a continuation of the suit. And therefore, it is not necessary that independent appeal should be filed. Same proceedings can be forwarded and it can be continued as an appeal also. Of course, we are not adopting that procedure. We file an appeal. It is to be attached with the certified copies. But now when we are dealing with so many technical things, I personally is of an opinion that now it's a time that it is not necessary. Parties are already present. Those who want to file an appeal, he should, after the decision, by taking a reasonable time, he can go and file an appeal memo in that same court, and without wasting the time of again exercising notices and then summons and then delay everything, it should be continued. So as far as possible, the aim and object of a speedy civil trial, which is guaranteed as a fundamental right under Article 21, as declared by the Apex Court, can be achieved. But it is a basic requirement that the court and the judge has to inform all these things when the judgment is given. Now, once there is a judgment, the same provisions, you can deal with the same provisions which we see now, Section 33, Order 20, Rule 1 to 20, Para 267 to 288 of the Civil Manual, and you can find out that again the procedure for a decree is there. Decree is to be prepared by the same judge. If he is transferred, it can be prepared by his another successor. It is to be prepared within the 15 days from the judgment, date of the judgment. And what is the date of the decree, friends? It is to be prepared within the 15 days. It is normally prepared after 2-3 months. It is already a choice of the Bhausab. He does as per his choice. So civil litigations are just prolonged and prolonged and prolonged for years together, Purna Mahabharat. But still, the decree, date of a decree is a date of a judgment. You can see the provisions. The decree, though prepared after 4 months, does not contain the another date because it is another parallel instrument coupled with a judgment whereby now the formal expression of an adjudication done in a judgment is to be reflected by way of a second document, and which is a decree. There the rights and parties, rights and all whatever the rights of the parties decided by the court or the issues resolved by the court is to be expressed, and that document is to be executed. For execution proceeding, judgment is not a document required. For execution proceeding, decree is the document required, friends. It is not the judgment which can be executed. Kindly note this, and therefore this provision itself makes the clear concepts of the judgment and the decree. These particular judgments or decree, once made, are not the final document. They can be corrected. See the provisions of Section 152, 153, and 153A of the Civil Procedure Code. You will find that the powers of making suo motu corrections are there to the judge. Of course, what is to be corrected? They can be clerical mistakes can be corrected. Arithmetical mistakes can be corrected. Any defect or error apparent on record is there, it can be corrected. A name of the parties is wrongly typed, address is wrongly given, survey number is wrongly made. Any such types of things are there that can be corrected. The reasoning cannot be corrected. Reasoning cannot be corrected. These all things can be corrected so moto by the judge because he is the author. He can make these all changes. That power is given under section 152, 153, 153A of the Civil Procedure Code. If such corrections are to be demanded by party, is there any right? Yes, of course. Parties can seek an application. They can make an application and point out to the court that, sir, either these mistakes are there. Of course, the scope is one and the same. Clerical, mathematical, error on record, these types of mistakes are there. It can be corrected by court suo motu or by party by making an application. It is not restricted, friends. All these types of corrections are there. Rectification is possible. You can see the Order 20 Rule 5. A specific word is used that it can be rectified if any mistakes are there. And by using all these things, the decree, document of a decree and a judgment is to be made a perfect document by the parties, by the court themselves. And therefore, the decree has a lot of importance. You all are, when you are going to join as a judicial officers, your skill will be reflected in a judgment and a decree. Your promotion will be there on the basis of the judgment and the procedure 50%, law 30%, analysis of the facts remaining percent. This will be your assessment done for your any further development of the career by the superior officers, and therefore your concept of the judgment, concept of the decree must be very clear, friends. This is one aspect. The decree can be of a different type. You know that. It can be preliminary decree. It can be final decree. It can be partly preliminary and partly final also. So let us see what is preliminary and final first. Preliminary decree means a decision is given by the court, but for finalization of a dispute, certain more inquiry is required to be done. In that case, it will be a preliminary decree. Final decree, decision is given by the court, and for implementation, execution of that decision of the court, no further inquiry is required. It is complete. The inquiry, the adjudication is complete. Preliminary and final. So inquiry required, inquiry not required. Only two criteria are there. That makes a difference of the preliminary decree and a final decree. A simple example, which you know, of a suit of partition. Sister files a suit against brother. That by virtue of this 2005 amendment, now I have an equal sharer. I want 1/2 share in this property. Brother takes a defense that no, it's an ancestral property. There cannot be a 1/2 share. I can give you at least this notional partition. Dispute goes on. Subject matter are the properties of the family. The evidence is laid and the judgment is given. Court decides that yes, now the sister has an equal share. So accordingly, order is passed, decree is made. So what is this decree? Yes, one half share is of plaintiff, which should be separated from defendant, and accordingly possession be given. One half share belongs to defendant, which will be retained by the defendant to him. Now, when the properties are immovable properties, it may be in a form of some constructed property, it may be from in a form of some land property, some agricultural property. This is a declaration of shares by way of a judgment, one half plaintiff, one half defendant. Now, which portion of the one half property is to be given? One portion is on a road front, another portion is on a backside. One property is a residential property, another property is a commercial property. How these shares are to be done now? This is a process of a final decree. So preliminary decree has done one thing, that one half belongs to plaintiff, one half belongs to defendant. Declaration of shares are done by the plaintiff, by the court, by preliminary decree. Now actually putting the persons in possession, after considering the valuations, after making an appropriate one half and one half share, because justice is to be done, it's not a mechanical process that, okay, 1 acre land, they give this half to this back portion to the sister and front portion to the brother. This cannot be done. So we call it as a by mitts and bounds, सरस निरस मानानं वाटप करणे. कुठली भारी आहे, कुठली हलकी आहे, कुठली व्हॅल्युएशन जास्त आहे, कुठली कमर्शियल आहे, कुठली रेसिडेन्शियल आहे. This is a process of a final decree. Once it is done, these types of division is prepared. Then the adjudication is going to be completed. Then the portion of the half portion containing some commercial property, some residential property to sister will be there, and remaining half will be with the brother. The evaluations will be equal. So the justice is done to them. So preliminary decree has only declared their shares. Final decree has given them a possession by making an assessment of their valuations, and a correct half portion accordingly is prepared by the court by taking the help of the revenue machinery during in an execution proceeding, and accordingly report is given to the court that yes, now this 2 acres to be given to this person, this is on back side, and the another place this 1 acre which is though on the front side, the less the area be given to one party. These suggestions are finalized before the court, and there the dispute comes to an end. The actual share is received by the party. So this makes the sense of justice. Here, now both party gets the complete justice by way of preliminary decree plus final decree. This is a concept of the preliminary decree, final decree. Some of the decree can be partly preliminary and partly final also. What is this? You can understand that this declaration of share and then the making of the share. Suppose a suit of a possession is there. I come with a case that my property, which is of my title, which was in my possession, has been taken in possession by defendant illegally. These reasons are there. I want a possession back, recovery of a possession. This is my suit. Court gives a direction that yes, now considering evidence, plaintiff succeeded that the property belongs to him. He is a title holder. He was a possession holder, and therefore the property may be given now. Property should be given from in a possession of the plaintiff. So possession relief is granted. There is nothing more inquiry required as far as the possession is complex. This is a final decree. But in that same suit, I come with a case that, sir, by taking this illegal possession, he has earned the money either by making a cultivation or giving that property on a rent. And this cultivation has ultimately affected my rights. In fact, it is my property, and on my property, illegal income has been derived by the defendant. So I want that income. It's nothing less than mesne profit. Mesne profit then means because of this all illegality, whatever income has been generated by the defendant, that should be given to me. Code makes a direction that, yes, now give possession to the plaintiff. B, makes an inquiry of the mesne profits, that is the income derived by this defendant during a period when the property was in possession. That inquiry is to be done. As per that inquiry, the amount is to be paid by the defendant to the plaintiff. Now here the second part is a preliminary decree. For that purpose, deciding the income generated by the defendant by keeping the illegal possession, inquiry will be conducted, the amounts will be finalized, and that amount will be submitted to the court, which will be recoverable through execution by the plaintiff. So this is first preliminary part, and then second, it becomes a final decree. So right, decree for the possession itself is the final decree, but decree for preliminary, for the inquiry of a mesne profit is a preliminary inquiry. It will be finalized only after making an inquiry of a mesne profit, and thereafter the decree will be executed to the extent of recovery of amount. As far as recovery of possession is concerned, it is not necessary to wait. Immediately, plaintiff can file an execution proceeding and go for the possession of that particular property, because possession is a final decree. So the decree can be preliminary, decree can be final, decree can be partly preliminary and partly final. This is the aspect of the decree. So I hope that this can be a basic concept of the judgment decree, preliminary decree, final decree, which should be in the mind. What are the powers to the judge to make the alterations? That should be in the mind. Which are the provisions that should be always, of course, in the mind of the upcoming judicial officers? Section 33 is important. Order 20 is important. Para 267 to 288 of the civil manual is important. Section 153, 152, 151, 152, 153A, they are the important sections. So friends, together makes a subject of the decree on it. Once you understand this, any type of a question which may come, which always comes on the decree, can be answered properly. You have to, first of all, preferably write the provisions, which provisions you have learned on this particular topic. I am sure if along with an order and section, if you can write some of the civil manual paras, it will be more impressed answer, because it is your duty. It is a document in the hand of judge, civil manual and the civil procedure code. Together, they have to use it for a proper administration of justice. When you will be sitting as a judge for a criminal matter, you will be using CRPC along with the criminal manual. And by taking the provisions of this particular procedure, you will be dealing with the criminal case. So friends, these provisions are to be quoted. Some of the basic concepts are to be explained. What is judgment? What is decree? The comparative parts of these two concepts of judgment and decree, you should explain that. And thereafter, you should give this all powers of execution, preliminary decree, final decree, partly final, and then you should conclude with your own remarks. So that can be a model answer on the point of the decree. So friends, this decree can be passed by an adjudication. This decree can be passed even ex parte. Ex parte decree doesn't require any explanation. It itself a concept that it is without the appearance of another party. Means ex parte decree means there is a valid summons to an opponent. In spite of summons, he either did not appear or he appeared and did not file a written statement. Two contingencies are there. Order 9 of the Civil Procedure Code deals with all these contingencies. You can go to the Order 9, Rule 1 to 12. You can see all the contingencies are discussed there. And it is decree which is passed by the court in absence of the defendant. So it is therefore said to be an ex parte decree. What defendant can do? Defendant is bound for an execution because there was a valid summons, he did not appear, or he appeared but did not file a suit, he did not contest the matter, and he accepted the contentions of the plaintiff. Therefore, it went unchallenged. It becomes an admitted fact because they were not denied by the court. Still, at this junction, it is a duty of the court to verify the truthfulness of that contentions before passing an ex parte judgment. Whatever relief, whatever subject matter is before the court, whether for that particular subject matter, the court has jurisdiction, Order 20, Rule 1, because the judgment is to be passed, it may be ex parte, does not mean that court can pass any judgment. For that purpose, court must see that whether on this subject matter, a jurisdiction is there. Court must see that the pleading and the documents given by plaintiff, whether they are forming a valid evidence under the eyes of the Evidence Act. And by considering all this validity of the proceedings of an adjudication, court can come to a judgment. So once court comes to this judgment, this conclusion that yes, I had a jurisdiction, there is a valid evidence, there are valid pleadings, the defendant has not opposed it, it stands admitted, and I can entertain this claim of the plaintiff, the court can pass a judgment. That becomes an ex parte judgment. So once an ex parte judgment is there, friends, and once it comes to the knowledge of the defendant, within 30 days, he has two options. Either he can make an application under Order 9, Rule 13 of restoration of that order, or he can go to the appeal under Order 41. Both remedies are there. You can verify. It's a concurrent remedies available. The difference is only that Order 9, Rule 13 application for the restoration of that ex parte decree is to be filed in the same court which passed that particular decree. And if appeal is to be filed to the superior district court. What should be the ground? They are given in Order 9, Rule 13. Summons is not properly served. It is not valid summons. There is some sort of a mischief place for service of the summons, mainly. The subject matter is not with the jurisdiction of the court. Or above all these things, any mischief played, fraud played for obtaining such type of an ex parte decree. As an advocate and even as a judge, such ex parte decree are of always unwanted exercise of the time. Many times, most of the times, they are set aside, and again on merit, the matters are remanded back. For that purpose, this provision is there, and therefore, this ex parte decree should be properly understood. So this is the in general, the provisions which I can put before you on this point of a decree and related topics. So this can, what I have seen from a question that on this particular aspect, sometimes explain decrees there, write short notes or decrees there, make a comparison of a judgment and decrees there. Then what is an ex parte decree? That type of questions are there. Whether decree can be corrected, amended on that particular aspects, the judgments are there. So you can cover up all this point on these important aspects of a decree and a judgment. The another important aspect is of jurisdiction. The jurisdiction of the civil court. In various manner, this topic has reflected in your question paper. I will just point out to in which type the questions appears. Exclusion. One question is that discuss statement court shall have a jurisdiction to try all suits of civil nature. Courts shall have a jurisdiction to try all suits of a civil nature. Discuss this statement. Then another question is that exclusion of a civil court jurisdiction is not to be readily inferred. Exclusion of the civil court jurisdiction is not to be readily inferred. Then another question, though in a cause of action, it relates to the jurisdiction. Cause of action, and when it can be said to be a cause of action arising to that particular party in that particular suit. Which types of preliminary objections can be raised for jurisdiction? What types of remedy are there for preliminary objections? Interim relief, whether can be granted after the preliminary objections? If interim reliefs are to be a jurisdiction of the civil court as far as the CPC is concerned. And that is a very short question. It's not a big question. It's a small question. And I must read that question for you. I had a CPC in my hand. I will read it. If you have a CPC in your hand, which should be there, in fact. In fact, I forget to give an instruction that whenever you are sitting for a particular lecture, if you have a bare act of that topic in your hand, it is always better. And it always gives you a correct perception of the subject. So 9th subject, 9th section, the court shall, subject to provisions herein under content, have a jurisdiction to try all suits of a civil nature, excepting suits of which the cognizance is either expressly or impliedly barred. Explanation: a suit in which the right to the property or to an office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on a decision of a question as to religious rites or ceremonies. Explanation 2, for the purpose of this section, it is immaterial whether or not any fees are attached to the office referred to the explanation 1 or whether or not such office is attached to a particular place. So the simple definition, simple provision in the respect of the jurisdiction is that all court has jurisdiction on all civil dispute. All civil courts have jurisdiction regarding all civil disputes. Civil, what is civil dispute? Civil dispute means which is not a criminal dispute. Simple thing. All others are the civil disputes. We differentiated it by way of saying that it is now revenue matter, by way of saying that it is a service matter, by way of saying that it is a banking matter, by way of saying that it is something caste matter, etc., etc. But in general, these are all civil matters. Criminal matters, yes, some offense is there, some violence is there, some murder is there, some half murder is there, etc., etc. They are all civil matter, criminal matters. So excluding these criminal matters, all matters are the civil matters. So 9th section, first of all, gives you an idea that civil court can entertain all types of civil disputes. No bar. Then second line, this is that yes, we can entertain all civil disputes excepting those of which, it is important friends, of which the jurisdiction is expressly or impliedly barred. See that last line of the section 9. All suits of a civil nature can be entertained excepting suits of which their cognizance is either expressly or impliedly barred. So you can, civil code can entertain all suits except those suits of which cognizance is expressly or impliedly barred. So simple thing, some of the law expressly bars the jurisdiction of the civil court. You must have come across many such acts, sections where a provision is there. Expressly barred means what? Written in a word by a section that yes, section 85, Maharashtra Land Revenue Code, that any matter relating to the revenue which is contained in this revenue code, Maharashtra Land Revenue Code, on this aspect, civil court jurisdiction will be barred. So you can't challenge that mutation entries are not correct in a civil court. You can't challenge that a particular taxation on the revenue record are not correct. These are all civil nature disputes. But a specific code, land revenue code, is prepared by the government where powers are given to that particular quasi-judicial authority. They will deal with that. What is your right? How entries are to be made? How your records are to be created? How Satbara is to be returned? How mutation entries are to be returned? Which tax is to be applied? This will be written in that particular manner given in land revenue code. So civil court will not entertain this. Therefore, the question is that this express bar is meant in that particular statute by way of the specific provision. Written, लिहिलेला आहे, सेक्शन लिहिलेला आहे की या कारणाकरता सिव्हिल कोर्टात जाता येणार नाही. कुळ कायद्यानुसार कुळ ठरवण्याकरता सिव्हिल कोर्टात जाता येणार नाही. रेंट ऍक्ट, महाराष्ट्र रेंट कंट्रोल प्रमाणे रेंट कंट्रोल ऍक्ट प्रमाणे चालवावं लागेल. लायसन्सी महाराष्ट्र रेंट कंट्रोल ऍक्ट प्रमाणे कॉम्पिटंट अथॉरिटीकडे चालवावं लागेल, सिव्हिल कोर्टात नाही. कास्ट व्हेरिफिकेशन to be done before the caste verification committee. Service disputes to be done before the Maharashtra administrative tribunal, central administrative tribunal, etc., etc. You know all these things. This is express bar. So this express bar is by letter, by sections, by provision. All right, you understand it well. No more explanation. What is implied bar? Because two words are used there in section 9. Express bar and implied bar. What is implied bar? Here many times the confusion arises. Implied bar means there is no express word as such. But still, the law makes it clear that this dispute is not to be brought before the civil court. How it is to be decided. I will quote an example. You know the building plans are prepared. building permissions are taken, layouts are prepared, layout permissions are taken. Many such activities are done. These are done under the Maharashtra Regional Town Planning Act, Maharashtra Municipal Corporation Act. Therefore, under these particular provisions, you will find that there is no such a specific provision in the Maharashtra Regional Town Planning Act that the bar, there is an express bar of the civil code. Of course, section 149 is there, which says that the various authorities orders done under this particular act should not be challenged in the civil court. But still, if you talk about the building plan, corporation gives a building plan and the another person says that this building plan is wrongly passed. The reasons are 1, 2, 3, 4, 5, 6. And he comes to the civil court again by filing a suit against that particular person as well as against the municipal corporation. Here in this particular aspects, friends, civil court jurisdiction is barred because impliedly on this topic, it is expected that if you are aggrieved by that building plan, you should file an appeal. The provision of appeal is there. You can further go into appeal. So parallel mechanism on this topic has been provided by the separate statute. And therefore, you should go to that particular statute. And therefore, impliedly, it is expected that you should not come to the civil court because you have an alternate remedy there. These types of the litigations are there. We have a little time, so we can quote many examples of this nature. But in short, meaning is that the express bar in a word by way of putting sections may not be there in that particular statute. But the scheme of challenging or scheme for an agitation, litigation on that particular topic is given in that particular act. So that is another alternate mode of a litigation available. And therefore, you can say that your jurisdiction is impliedly barred, friends. This makes you the jurisdiction as far as the section 9 is concerned, concept of the jurisdictions. Then comes which kinds of the jurisdictions are there. You know, pecuniary jurisdiction is there relating to the value of the subject matter. Suits of 5 lakhs, suits of 10 lakhs, suits of 1 crore, suits of 50 crores, different valuations are there. So if it is up to 5 lakhs, it will be civil judge junior division. If it is above 5 lakhs, it will be civil judge senior division. If it is appeal, then up to 1 crore rupees, it will be a district court from the appeal, from the decree of the civil judge junior division. And if it is above 1 crore, it will be a high court. These all jurisdiction things are based on the pecuniary value of the subject matter. So this is a pecuniary jurisdiction based on the valuation. The territorial jurisdiction is there. If I am at Nasik and some properties at Nasik, somebody make an agreement at Mumbai and suit is to be filed, the territorial jurisdiction will be at Nasik, though the agreement is done at Mumbai, or it may be at Pune, it may be at any other place. The territorial jurisdiction bounds me to make this particular jurisdiction at this territorial jurisdiction. So it is a territorial aspect of the jurisdiction, which is, friends, and important. It may be the jurisdiction based on some of the subject matter. It may be some matrimonial disputes. Then it may be a family court or family court. Apart from that, if you want to file some civil suit for a declaration of status, etc., friends, then yes, of course, the marriage, the place of marriage, where the husband and wife resides. So such types of the Different types of disputes are there where the subject matter makes the disputes. Suppose an agreement is there, and parties have agreed that the jurisdiction will be restricted to at XYZ place on that particular subject matter. Here, the law is very clear. Suppose on that particular dispute subject matter at A place and at B place, jurisdiction is there, and parties are choosing that out of A and B, we will fight out this matter at B. It is permissible, such contract, and it will be binding on the party. But if at all jurisdiction is not there on that particular subject and some contract is made, the contract is beyond the law and it cannot be entertained. So the jurisdiction based on the subject matters are there, friends. Then jurisdiction of some special types of jurisdictions are there. Just we talk like the caste verification is there, or some service disputes are there, some various types of other tribunals are there. Even you can take the case of the motor accident claim. The claims are to be filed not before the civil court. They are to be filed before the motor accident tribunal, which is a designated tribunal of a district court. It is not a district judge sitting as a district court in that capacity, but it will be a district judge sitting as a motor accident tribunal, motor accident claim tribunal in accordance to the Motor Vehicle Act. So these are the special types of a jurisdiction which can be considered. And therefore, these types of jurisdiction, if you have to summarize the types of jurisdiction, if you are talking on the jurisdiction, you should understand that pecuniary, territorial, subject matter, special types of jurisdiction. This will give you the basic theme of the jurisdiction, which types of jurisdiction can be entertained, and what are the necessary things which are there, friends. So jurisdiction is also important aspect. If a jurisdiction is not there, then any order, judgment, or any proceeding is ineffective. Ineffective to this extent that it is null and void. Null and void means it does not exist at law. Nobody can take the cognizance of such null and void things. It may be any order, it may be any judgment, it may be any other proceeding. If it is without jurisdiction, it goes to the root of the matter, friends. And therefore, nowadays, we had a repeated agitations and disputes on this point of jurisdiction. You know the famous provision of Order 7, Rule 11. The application, once the plaintiff comes, the written statement comes afterward. First comes Order 7, Rule 11, application. The Honorable Court has no jurisdiction to entertain this matter. 1, 2, 3, 4, 5, 6 grounds. In a Maharashtra, there was a 9A section, of course, which is now repealed, which was restricting the relief of interim injunction if an objection on the ground of jurisdiction is raised. Then in the 9A section, it was there that you cannot go for the hearing of the interim injunction unless and until the point of jurisdiction is decided. Now it is not there, so we need not discuss that. There are many questions on that particular topic, but I hope that it will not come when it is applicable, when not applicable. The one amendment come on that point, second amendment come on that point. Simply, if it is now a question of an objection, it's not necessary that the interim injunction should be stayed. The Exhibit 5 will take its own course as per its own procedure. Simultaneously, if it is objected on the ground injunction will come. Of course, at the same time, there is no possibility of extending the hearing of the jurisdiction also. Nobody can compel or say to the court that now, sir, here the injunction and this jurisdiction issue be taken up along with the final suit, and it may be included in the issues. No, law says that it should be heard immediately, because what is the purpose? If at all it is going to be a case that there is no jurisdiction to the civil court, then entire exercise of hearing of the suit will be a waste of time for the court and for the parties also. So it is to be avoided. So therefore, friends, these particular aspects of the jurisdiction are important, and I will just say that for this purpose, you can go to section 9. You can also see order 20 on these particular aspects. Also, you can see the aspects of the civil manual, where the judgments and decree you are verifying at that particular time. You will also get the aspects of the jurisdiction. So jurisdiction is an important topic, and you should understand types of the jurisdiction we have already discussed. And considering this, you will get a good aspect, good material on the topic where whatever may be the questions. Here it is one connected question is of a return of the plaint. And that return of the plaint is also important, because if a jurisdiction is not there, then it is a duty of a court to return that plaint, not to entertain that plaint, return it for presentation of that plaint to the correct court. For that purpose, the plaint can be returned, rejected, even under order 7, rule 11. The provision of rejection of the plaint is there. If jurisdiction is not there, then under order 7, rule 11, subclause B, that plaint is to be rejected by the court. This rejection will be simply the rejection. It will be a decree. Whenever a plaint is rejected, it amounts to decree, because that is included into the definition. Suppose you object under order 7, rule 11 for the jurisdiction, and your application is allowed and suit is rejected. That will amount to decree, friends, because the definition of a decree includes rejection of the plaint. But if that application is rejected, means what? The court has jurisdiction. This order is not a decree. This order is simply an order which can be challenged in accordance to the other part of the procedure. Appeal against order, whatever your provisions are there. But it is not a decree. You can't file an appeal against that. You can file another appropriate procedure. So this is a difference. Rejection means you are terminating the remedy, which is a serious types of remedy, and therefore it always requires a reasoning and explanation. So this particular aspect must be kept into mind whenever we are dealing on the point of the rejection also. Cause of action. Cause of action is simply defined as a bundle of facts. It is a bundle of facts constituting the subject matter whereby a relief can be claimed by the plaintiff. There is no definition as such, but of a cause of action, but it is a right to sue, friends. Cause of action gives you right to sue, and it consists all the material facts imperative for a plaintiff to make an allegations against the defendant and to prove that and succeed in the suit. So cause of action is a right to sue. Unless and until that cause of action is mentioned in a plaint, your plaint will be rejected. It cannot be entertained. So it's necessary in the entire plaint, as the names of the parties are important, the cause of action is equally important. The valuation is equally important. The jurisdiction is equally important, and the relief is equally important. The rest of the material, you may change it, you may add it, you may alter it, you may amend it. You can't amend these particular technical aspects of cause of action and other technical aspects of the plaint. So whatever plaint is described in Order 7, you will find a list of the plaint, what is the requirement of the plaint. In that particular requirement, cause of action is the most important aspect which should be understood by the all practicing lawyers. So this is something about the jurisdiction. If jurisdiction is not there, it will be rejected and it can be returned to the complainant also for presentation before the proper authority. So friends, with this, now considering the time constraints, we will go to the last topic, which is regarding the interim orders, interim injunction particularly. Nowadays, it is said that suits are only made for interim injunctions. It's a bold statement, but it's a fact of the civil litigations. The life of interim order is the life of the suit. And therefore, before judge, the most challenging aspect which comes every day is Exhibit 5 application or some in other form, some interim injunction. This interim injunction, which is to be entertained particularly in light of Order 39. And in this Order 39, if you see what is expected for the purpose of a proper understanding, I will read for you that 2-3 lines of Order 39, which must be understood properly. Order 39 is an independent procedure for the purpose of getting temporary injunction. And for that purpose, right from Order 39 Rule 1 to Rule 10, provisions are important. That should be always repeatedly read by the lawyer and the judges. See, in Rule 1, the cases in which the temporary injunction may be granted, where in a suit it is proved by affidavit or otherwise, A, that any property in dispute in a suit is in danger of being vested, damaged, to defrauding his creditors. C, that the defendant threatens to dispose the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in a suit, the court may, by order, grant a temporary injunction to restrain such act or make such other order for the purpose of staying, preventing the waste, damage, alienation, sale, removal, disposition of property, or disposition of the property, otherwise causing injury to the plaintiff in relation to the any property in dispute in the suit, as the court thinks fit, until disposal of the suit or until further orders. Whatever importance of the bail in a criminal matter is there, the similar importance of the interim injunction in civil matters are there. You know that. So, suit is filed, and for the purpose of keeping suit alive and not making the purpose frustrated, it is only possible if you can obtain the interim injunctions. And therefore, it becomes important. It is, of course, in a form of an application attached with a affidavit. So, question comes whether it is a pleading. You pleaded in a suit. You also pleaded in Exhibit 5 application certain allegations attached with an affidavit. The question will be asked either in an exam or in an interview whether the contentions made in an application Exhibit 5 interim injunction is a pleading. What should be the answer? Many times I have found that the young friends bounce to an answer and say, yes, it is a pleading. No, friends, it's not a pleading. Because what is pleading is defined in Civil Procedure Code as a plaint and a written statement. This is neither a plaint nor a written statement. It is just one of the application. And therefore, it is not a pleading. It is your contention. Court will consider it. You have to disclose it. Complete facts are to be disclosed on affidavit. If you are hiding, your injunction will be refused. But similarly, it is not a pleading. So it is just a relief of an interim nature till the suit is finally heard and decided on merit, for which a time is required. This particular aspect of an injunction is required to be considered. The most important aspect of the injunction is principle of equity. One who claims an injunction should come to a court with a clean hands. You must have heard this. Defendant may not come with a clean hands, but he is not asking an injunction. Plaintiff is asking an injunction. He should come with a clean hands. What is mean by clean hands? Clean hands means you should give a true facts. You should not be guilty of any wrong. You should not make any suppressions of the facts. Your conduct should be such that it shows a fairness to the court, fairness towards the party also. In spite of your truthfulness, fairness, everything, if the defendant is troubling you, if he is damaging your property, if he is wasting your property, if he is alienating your property, if he is dispossessing you, if he is causing loss to you, any sort of the relief which is granted there in Order 39, you can ask an injunction. And if that fairness is proved by establishing 4 factors, not only 3, prima facie case, balance of convenience, irreparable loss caused to the plaintiff, and 4th, conduct of the parties, by making an examination of these 4 criteria on the basis of the contention of an application, affidavit attached thereto, and documents supplied in support of that, court will consider your interim injunction. For that purpose, the entire procedure from Rule 1 to 10 is given. This can be varied, this can be changed, this can be set aside, given injunction. This cannot be obtained by misleading. If it is obtained by misleading, then it can be anytime revoked. Court has to decide it within 30 days. This particular inquiry of an interim injunction can be done by making a separate inspection of this disputed spot. Many times these provisions are not known or they are not used. And general provisions of the appointment of the commissioner are done. Rule 7 should be understood. It is a power under Order 39, Rule 7, that for purpose of deciding the injunction, the honorable, with an order of an honorable court, you can make an inspection of the property. You can take the samples. You can make any examination. Many more aspects of this initial inquiry before making a hearing of Exhibit 5 application, interim applications are possible. And that for that purpose, you can always see this provision. Here, I will point out that to the Central Act of Civil Procedure Code from Order 39, Rule 1 to 10, you have to remember that After Rule 10, Rule 11 is there. That is a Bombay High Court amendment. In this Rule 11, a provision is made that if anybody is making a breach of this interim injunction, it is not necessary to go to the contempt of court. You can go it as an independent proceeding. That cannot be filed in the same application, say application in the same proceeding. It is an independent proceeding, contempt of court. But in a same proceeding, you can make an application that plaintiff obtained the injunction, but he made a breach of that. And therefore, suit should be dismissed. And his suit will be dismissed. If defendant make a breach of the order of interim or injunction, plaintiff can make an application that in spite of an injunction, the breach is made and therefore a defense of the defendant be struck down. This is possible because Bombay High Court amendment in order 11, order 39, rule 11 is there, which should be seen by the advocate from the Bombay within the jurisdiction of a Bombay High Court. Many such types of High Court amendments are there, friends, and they are to be understood. So this is a important aspects of interim injunction. Interim injunction is subjected to appeal as an appeal against order. Civil miscellaneous appeal, you know that. If the jurisdiction permits you, you can come up to 1 crore rupees in a district court. If it is above 1 crore rupees, then wherever the appeal from the decree will be lie. If it lies to district court, appeal against order will be at district court. If it lies to high court, appeal against order will be at high court. Accordingly, you have to look towards the provisions of an interim injunction. So you should understood order 39, rule 1 to 10. You should understood the High Court amendment under order 39 to rule 11 onwards. And on the basis of this, you should verify the civil manual for the purpose of hearing of interim injunction. Time is short. I have taken a sufficient time. I know you have to study yourself. I don't know whether this all exercise of a bar council to take your valuable time at this last stage of an examination is useful. But I hope that whatever the feedbacks are given, that this contributes you to give a momentum to your own thought process for answering the questions. The proper answers are only achieved in a law if you have understood that particular concept and theme of that particular provision. Otherwise, just understanding the words, we can't reach up to the aim and object. And therefore, whenever the laws are to be interpreted, one has to see what are the aim and object of that particular law or that particular provision. I hope that you will understand the aim and object of the Civil Procedure Code is to provide a procedure for giving a proper speedy relief to the litigants, and at particular stage of the matter apply particular provision. Don't go here and there. See the division of the sections made in the act itself. See how they are separated, why they are separated. See that divisions. Connect the sections with orders. Verify which High Court amendments are available. Try to use that High Court amendments, and with use of these sections, order, High Court amendments, take the use of civil manual. You are going to be judge, friends, and on judge table, you will find that the civil manual is the unavoidable document. So try to find out that civil manual. You will find out that manual, a big book is there, and take the help of that manual when you will try to study Civil Procedure Code. Thank you very much. All the best. Be successful. Bring big number of a successful candidate in a JMFC exam for the Maharashtra, and become a good, wise judge. Thank you very much.
Thank you so much, sir. Just a minute. I request Advocate Shabnam Kazi ma'am to offer vote of thanks.
Thank you, Ganesh. I'm immensely thankful to our dear Jaibhave sir, who has been our pioneer in building confidence of all of us in pursuing judicial career. CPC, which is generally a procedure and which is the basis for our practice, has always been a difficult subject. But Jaibhave sir always in his lectures have been making this subject a very easy one for us to understand, both from the practical point of view of practice as well as judicial aspirants. He has highlighted and made easy several topics which are the core of the exam papers, like decree, mean profits, jurisdiction, interim injunctions, and such provisions which will not only help us as judicial aspirants but also make it easy for our day-to-day practice in the civil courts. He has also highlighted the importance of civil manual both for a judge as well as for a lawyer. I thank him for this immense knowledge which he has given to us and made CPC so easy for us. I also thank the participants for giving a patient hearing to this lecture. Thank you.
Thank you.
Thank you so much, sir.
Thank you.
Tomorrow there will be lecture of Advocate Tejas Dande sir on offences relating to property under IPC. I request all of you to join at 6 for the lecture. Thank you so much. I request Sharad Babul sir to end the meeting.
Thank you very much. Thank you all.